Hello, my friends. My name is Sergiu, and I am a judicial trainee here in the Romanian National Institute of Magistracy. It is my pleasure to be your host and guide today. Let's take a tour together throughout the Romanian judicial system, shall we? We should probably start by stating that, according to the Romanian Constitution, judicial authority is exercised by the courts of law, the public ministry, and the Superior Council of Magistracy. Justice is administered by the High Court of Cassation and Justice and the other courts of law set up by the law, namely the Courts of Appeal, the District Courts, the Specialized Tribunals, and First Instance Courts. The High Court of Cassation and Justice is the highest court in Romania, and its fundamental role is to ensure the smooth interpretation and application of the law by the other courts. At a national level, there are 15 courts of appeal, each having jurisdiction over an area comprising 2 to 4 counties. In each of Romania's 41 counties, as well as in the municipality of Bucharest, there is one district court located in the county seat. There are also 4 specialized tribunals, 3 with jurisdiction in commercial matters, and 1 competent for cases concerning minors, children, and family law. Across Romania, there are 176 first instance courts. As of 2025, there are 4,251 judges and 2,266 prosecutors actively serving within the judicial system. Each court of law is led by a president, assisted by 1 or more vice presidents, depending on the level and size of the court. Additionally, each court has a management board which takes decisions on important matters related to the court management. The public ministry is structured in a hierarchical system. It is led by the Prosecutor General of the Prosecutor's Office attached to the High Court. The Superior Council of Magistracy is the guarantor of independence of the judiciary. It has exclusive competence regarding the recruitment and career management of judges and prosecutors. It also acts through its specialized divisions as a disciplinary court and exercises other powers provided by law. The Ministry of Justice, as part of the executive power, is not included in judicial authority. Nevertheless, according to the law, the Ministry of Justice is responsible for ensuring the proper organization and administrative functioning of justice as a public service. The budget of the Courts of Appeal, District Courts, and First Instance Courts is, however, managed, at least in terms of personnel expenses, by the High Court. In the next video, we will explore Romania's main judicial institution. Let's watch it together.
General overview of the Romanian judicial system. According to the Romanian Constitution, justice shall be rendered in the name of the law by the High Court of Cassation and Justice, and by the other courts set up by the law. First instance courts are organized at local level and decide in first instance the cases provided for by law. A decision pronounced by the first instance courts may be challenged with appeal to the Superior Court. Tribunals are organized at the level of each county and in Bucharest. They rule in first instance, but also solve the appeals filed against the decisions handed down by first instance courts. The courts of appeal solve the appeals filed against decisions pronounced by tribunals and first instance courts, but also other cases provided for by law. The military courts of appeal rule in cases of criminal offences committed by the military, given by law in their jurisdiction. The High Court of Cassation and Justice shall provide a unitary interpretation and implementation of the law by the other courts of law, according to its competence, but also decides upon the appeals against decisions pronounced in first instance by the courts of appeal and other cases established within its jurisdiction by law. Within the judicial activity, the public ministry represents the general interests of the society and defends legal order, as well as the citizens' rights and freedoms. The public ministry exercises its powers through public prosecutors, constituted into public prosecutors' offices in accordance with the law. The public prosecutors' offices attached to courts of law direct and supervise the criminal investigation activity of the police according to the law. The prosecutor's office attached to the High Court of Cassation and Justice coordinates the activity of the subordinate prosecutor's offices and manages the public ministry's budget. Within the General Prosecutor's Office there are two specialized prosecutor office structures: the National Anti-Corruption Directorate and the Department for Criminal Investigation of Organized Crime and Terrorism. The Superior Council of Magistracy is an independent authority, subject only to the law, which, according to the Romanian constitution, guarantees the independence of justice. The Judicial Inspection is an independent institution that analyzes and verifies the activity of judges and prosecutors. As far as the career of magistrates is concerned, the Superior Council of Magistracy exercises several duties and coordinates the activity of the National Institute of Magistracy, which recruits and trains judges and prosecutors. The Superior Council of Magistracy also coordinates the National School of Clerks, which recruits and trains the clerks and the court assistants.
By law, there are two ways to become a judge or prosecutor in Romania. Law graduates without previous legal experience can take the entrance exam for the National Institute of Magistracy. Law graduates with at least 5 years of legal experience can apply directly through a separate exam for entering into the judiciary. The structure of the two admission examinations is identical. However, candidates admitted to the National Institute of Magistracy become trainees and undergo a 2-year initial training program. Candidates admitted through the direct entry examination become judges or prosecutors immediately. We invite you to watch a video illustrating the journey of one candidate, whom we named Alex, through the admission exam and then throughout the initial training process until he becomes a definitive judge.
Alex, a graduate of the Faculty of Law, wants to pursue a career in the legal field. After analyzing different options and discussing with family and friends, he chooses to become a judge or a prosecutor, so he decides to take the admission test. After consulting the contest's rules, he carefully prepares his application file and follows the online registration procedure. He prepares intensively for the eliminatory written tests. The first test is a multiple-choice test, which Alex passes successfully. 2 additional written tests follow, held on separate days, in which Alex must solve theoretical and practical subjects. After passing this stage as well, Alex successfully takes a psychological test and continues with an interview before a committee that assesses his motivation, skills, and ethical profile. The Superior Council of Magistracy verifies his good reputation and validates the competition results, and Alex is admitted to the National Institute of Magistracy. He attends courses and seminars where he learns how to approach his future profession from a practical perspective, completes internships in courts, where he observes judicial proceedings, then internships at the prosecutor's office, where he participates in criminal investigation activities. He also practices in law offices and participates in other activities such as the Miss competition and international exchange programs. At the end of his training, Alex passes the graduation exam and then chooses between the profession of judge or prosecutor. An internship period follows, which concludes with an exam that Alex passes successfully. Finally, Alex is appointed by the President of Romania as a judge or a prosecutor and begins his career in the judiciary.
Judges are independent and subject only to the law. They adjudicate cases based on the law, ensuring that the procedural rights of the parties are respected, free from any constraints, influence, pressure, threats, or direct or indirect interference from any person or authority. Moreover, the law establishes an obligation for all persons, organizations, authorities, or institutions to respect judicial independence. Judges appointed by the President of the Republic enjoy security of tenure, meaning they cannot be transferred, reassigned, seconded or suspended without their consent. They may only be removed from office under the conditions expressly provided by law. Prosecutors are also independent in exercising their duties. They act in accordance with the principles of legality, impartiality, and hierarchical control under the authority of the Minister of Justice. The principle of hierarchical control distinguishes prosecutors from judges and defines their different type of independence. The public ministry is a pyramidal structure. Prosecutors at each level report to their immediate superior, and each head prosecutor reports to the head of the higher level prosecution office. As such, decisions made by a prosecutor can be overturned under the law by their direct superior or by the Prosecutor General of the Prosecutor's Office attached to the High Court. Prosecutors do not belong to judicial power and do not administer justice in the same way as judges do. Their constitutional role is to defend the rule of law, protect citizens' rights and freedoms, and represent the general interests of society. Next, we invite you to watch a video that presents the legal journey of a claim through the court.
The administrative circuit of a request. Any trial begins with the notification of the court that bears different names: lawsuit, complaint, litigation, etc. Regardless of its name, the document notifying the court may be submitted at court registry in person, by mail or online. Here, the relevant information is entered in ECRIS, an electronic application, in order to create a file. Judges play a key role in the courts. They solve the cases in panels made up of one or several judges. The judges solve the case file by issuing a judgment and giving reasons in a court decision that specifies how they reached the solution.
Now, let's briefly talk about court jurisdiction. First instance courts adjudicate cases exclusively as courts of first instance. District courts and courts of appeal have competence to hear cases both as courts of first instance in more complex matters and as courts of appeal or cassation, reviewing decisions issued by lower courts. At first instance, cases are typically heard by a single judge. Appeals are adjudicated by panels of 2 or 3 judges, depending on the applicable procedural rules, while cassation appeals are reviewed by panels of 3 judges. The High Court of Cassation and Justice adjudicates appeals for annulment against a decision issued by the Courts of Appeal. In criminal matters, it has jurisdiction at a first instance court for certain cases provided by the law. It also hears appeals and cassation appeals in accordance with the applicable procedural framework, with panels of 2 or 3 judges depending on the case. Mechanisms designed to ensure the uniform interpretation of the law include the appeal in the interests of the law and preliminary ruling, whereby the High Court resolves legal issues that have been interpreted differently by the courts. What is the structure and the contents of a court decision, the final and most important procedural act by which a court resolves a dispute? You will find out in the next video. We will also present a video about the appeal within the Romanian judicial system.
The trial, the court decision. The court decision is the final and most important act of the judgment, by which the court solves the dispute between the parties. The act is called decision when the court rules in first instance, and final decision when the court rules on appeal. All the other acts during the trial are called hearing reports. We have a specific terminology, depending on whether the court rules on appeal or on a further appeal on points of law. The court decision has 3 parts. The introductory section, presenting the court, the panel, the parties, their conclusions, as well as any other mentions regarding the procedure, the evidence, or regarding the debates. The second part is called considerations in the civil trial and narrative description in the criminal trials. It includes the main factual and legal grounds which led the court to adopt the respective decision. The operative part, the third part of the court decision, includes the solution pronounced in the resolution of the dispute. In criminal matters, the operative part of the decision must also include the decisions of the court in relation to the punishment, the preventive, the ensuring, or the safety measures. The court decision must be signed by the members of the panel and by the clerk. A copy of the decision is sent to the parties, but also to the other participants in the trial, or to different institutions, according to different special legal provisions. The court decision has the probative force of a written, authentic document. The court decision is binding and takes effect only between the parties and their successors. It is enforceable against any third party as long as the latter does not prove the contrary. The appeal proceedings. The appeal is the phase of the trial in which the party that is dissatisfied with the decision of the court seeks this remedy. The parties in the proceedings, the persons or the bodies that, according to the law, have the right to appeal, can exercise it only once against the same decision. Filing the appeal must be done at the court whose decision is being appealed, while the appeal itself is decided upon by the higher court. Only decisions can be appealed. The rulings pronounced during the trial can be challenged only along with the decision. Appeals can be ordinary or extraordinary and differ depending on the specifics of the civil or criminal trial. Extraordinary remedies cannot be exercised as long as an ordinary appeal is open. The deadline for filing an appeal is provided by the law. Failure to comply with it may result in the rejection of the appeal as statute barred, in which case the criticism of the contested decision, even if it is justified, can no longer be analyzed by judges. The reinstatement within the deadline for filing an appeal may intervene upon request, and only if the delay is proven to have been caused by reasons thoroughly justified. Therefore, after the cessation of the impediment, the party will have to complete 2 acts within the deadline provided by the law for filing the appeal: to request the reinstatement within the deadline and to file the appeal.
We believe that we cannot conclude this presentation without offering some details about the status of judges and prosecutors, including the disciplinary sanctions applicable to them. First, it should be emphasized that judges and prosecutors are incompatible with any other public or private position, except for academic teaching positions in higher education. Judges and prosecutors are prohibited from engaging in commercial activities, serving as arbitrators in civil or other disputes, holding the position of associate or member of management, administrative or supervisory bodies of companies, credit institutions, or financial entities. Judges and prosecutors may not be members of political parties, engage in political activities, or publicly express or display their political beliefs in the exercise of their duties. They are also prohibited from publicly expressing opinions on ongoing cases, whether their own or those of their colleagues. Nor may they give legal advice in contentious matter, even in cases pending before courts or prosecution offices other than their own. And they cannot engage in any other activity typically reserved to lawyers. Judges and prosecutors cannot join or form trade unions, and they may not go on strike. As in any other legal systems, failure to fulfill their general and specific duties leads to disciplinary liability. The sanctions provided by law for disciplinary misconduct vary depending on the gravity of the offense, as determined by the disciplinary sections of the Superior Council of Magistracy. We hope this overview helped you understand how the Romanian judiciary is structured and the key principles that govern its functioning. Perhaps it sparked your interest to look into more. We look forward to seeing you to Romania. Goodbye.